Welcome back to the Emily Show, Landlord. We have much to talk about this week, and if you have been on stream with me for the Brian Walshe trial, you might know a bit of what's coming today, but you're never going to believe what is happening in the lawsuit against Brian Walshe's mother. You heard me correctly. We are going to be talking about the landlord that we saw testify in the Brian Walshe trial last week, suing Brian Walshe's mother, who has been in court, it seems, day after day in this case. And if you haven't been in court with me all day, every day, because it's December and there's much to do, do not worry. I will catch you up on what you need to know from the trial as it plays into this civil case that asks a really interesting question. What responsibility does the person leasing a residence have if a horrific homicide occurs in that home? So yes, we are going to be talking about Brian Walshe's mother being sued over the murder of Ana Walshe in the residence, if that murder did in fact occur in the residence. Because again, in the murder case, the defense is arguing that Ana Walshe died of natural causes but was dismembered in the home and then disposed of. We need to take a look at this civil lawsuit, and if you hang around to the end of the episode, I have an update from court in Los Angeles, and we have a quick update in the Kouri Richins case as well. So let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. So, fun little Landlord story time. On Friday, you know that I was scooting off a stream because I was headed out. We went to go watch the state championship football game. My son's high school won their state championship football game for the first time in the school's history, and we have been to state championships numerous years in a row and lost. So I was not sure if sitting out in 40-degree weather was going to be disappointing or not, but we went to the game because senior year and just what if it was. But on the way there, I was attending remotely the Kouri Richins hearing in the car, and Dr. B was like, "What case is this? The judge has quite a striking voice." And I'm like, "Dr. B, I have been talking about this case for years," but now he has experienced it too. And Dr. B is also charmed by Judge M's courtroom demeanor and his dulcet court tones. But Kouri Richins was back in court with all of the attorneys on her first appearance on the other criminal case. Remember, I covered it a while back. We'll link it down below, but prosecutors charged Kouri Richins with the mortgage fraud allegations and other of the fraud allegations in a separate filing because some of those had been taken out of the murder case anyway. They were a bit more remote in time. So the second case that is facing Kouri Richins now, we've already talked about, but it was technically her first appearance in court on that case. This case is just trailing along behind the murder case. Nothing is going to happen on it until the murder case is done, but it was her first appearance in court on that. So if you hear Kouri Richins has a new case, we covered it months ago. It's not new. It was just her appearance on it. If you are unfamiliar with the Kouri Richins case, this case is getting ready to go to trial in February. She is accused of poisoning her husband with fentanyl, supposedly in a Moscow Mule that she made for him that evening. Then she wrote a children's book about grief, and while she was promoting that book, was arrested for the murder of her husband, which shocked everyone. And I was chatting much about it at BravoCon with the Real Housewives of Salt Lake City because I was like, no, and then the Maverick and Draper, this is what was going on. And if that doesn't ring a bell, you might remember the Kouri Richins case from the walk the dog letter. And yes, there are numerous motions still pending about whether the walk the dog letter will be something the jury will get to see or not, and those haven't been ruled on yet. All of those types of motion hearings have been put over for early January ahead of the trial in February. And there's going to be about 2 weeks of jury selection. We're not going to see any of that. So we really won't be starting trial coverage until late February. And remember, this judge has said no live streaming. So I'm not sure how this one's going to go, but we'll have to wait and see. Disappointingly for me from the hearing, the judge gave the attorneys pretty much carte blanche to file everything they want under seal until the trial starts, to not potentially poison the jury pool with information about the case. So we might not even see the filings on the motions in limine because the court really said, whatever you want to file for, attorney's eyes and court's eyes only, go right ahead. And I don't know if the media will try to intervene in this case the way they did in the Kohberger case to get those things not filed under seal, seeing that the trial's coming up in such short time. So getting information on this case might get a little bit more tricky, but there are 2 hearings happening in January, and I will be keeping a close eye on that. Sometimes you are stuck on what to get somebody for the holidays, or maybe you just want to be stuck under the coziest blanket on earth while you catch up on your favorite TV with your paw nerd in front of a fire. Emily, is that what you're doing every day after trial coverage? 100%. What I love about the Lola blankets is the 4-way stretch because it has a little bit of give, so it's real nice to tuck around your feet. Plus, it's all double hemmed and it's machine washable, so you don't have to worry about it falling apart. Lola blankets are quality that you can feel, and you've probably clocked them in some of your favorite unscripted television and on social media because I am seeing them everywhere. Plus, they come in a ton of different colors. Look, I have several now and I need more because everyone keeps stealing them from me. But what I love about this one is that it actually matches the cats, so it makes it even easier. And fun fact, my first Lola blanket was actually a gift that I received, and it has been hands down one of my favorites. You can find your perfect cozy vibes with a tremendous discount at lolablankets.com. For a limited time, Emily Show listeners get 40% off their entire order at lolablankets.com. You heard me correctly. 40% off your entire order at lolablankets.com using code LAWNERD. Use our exclusive code LAWNERD at lolablankets.com to get 40% off. And if they ask how you heard about them, let them know it was the Emily Show. Let's get back to today's show. And something I turned my eyes to this week as we were covering the Brian Walshe case. Yes, we are back in live trial. If you don't have the Lawnerd app at lawnerdapp.com, you might be like, wait, Emily, what live trial? I know. We built the Lawnerd app so we could keep you in the loop with the cases that you want to follow. And even sometimes the cases you don't want to follow. And then you're like, but if we're in trial, let's just do it. So we are back in Massachusetts covering the Brian Walshe case. He is on trial for the alleged murder of his wife, Ana Walshe. Up until trial, this had been a disappearance case. Law enforcement was told by Brian Walshe that Ana Walshe left the home, went to Logan Airport, was commuting back to work in Washington, D.C., and then no one heard from her again. Right before jury selection, Brian Walshe pled guilty to the dismemberment and disposal of Ana Walshe and to lying to law enforcement. And now that we're a week into trial, I can see why. The evidence on that's fairly overwhelming. In opening statements, the defense said that Ana Walshe died of natural causes. And yes, opening statements are not evidence, but I think Brian Walshe is going to testify. He's going to say exactly what his attorney said in opening statement. Early on New Year's Day, overnight from New Year's Eve to New Year's Day, he went to go get into bed, and he says he nudged, this was coming from opening statements, nudged his wife and she was non-responsive. And then he didn't know what to do and he freaked out. And the lawyer said in opening that Brian Walshe didn't want his kids to think he had done anything bad to their mother, which was an odd phrasing for me. And I wonder if we will see Brian Walshe say something similar on the stand. So he has admitted to the disposal and dismemberment, but is going with the Robert Durst defense really of, but I didn't commit the murder. I did the other stuff, but I didn't commit the murder. Well, in a side note to all of that, we saw the landlord testify about the home, and some of it was to identify a rug that we are just getting into the evidence as of Friday about, and this rug was found and recovered in trash bags in a dumpster right at the defendant's mother's apartment complex, and those were submitted to the coroner. The coroner is on the stand, and we are just starting to see pictures of that cut up rug that was recovered from numerous trash bags. So the damage to the home is the heart of the lawsuit against Brian Walshe's mother. And Brian Walshe's mother has not been tremendously responsive in this lawsuit. And there are some questions in the interrogatories that she did not answer, including, did you conspire with your son to kill his wife, Ana Walshe? So we need to take a look at what's popping off in this lawsuit because there have been some very unfavorable rulings to Brian Walshe's mother. And this case has not gone well for her. So let's take a look at the complaint that was filed and the underlying basis of the causes of action. Then we're going to take a look at what the court's doing, because that's really where the information about Brian Walshe's mother really not wanting to participate in this lawsuit at all. So let's take a look. All right, we are taking a look at this civil lawsuit from Norfolk County. This is Peter Capozzoli. He testified at trial in the first week of the Brian Walshe murder case as the trustee for BEC Bermuda Realty Trust versus Diana Walshe, Brian Walshe's mother, and the Massachusetts Property Insurance Underwriting Association. This was filed May 31st, 2023. I am not going to be focusing on him suing his homeowner's insurance, though it does raise the question: if a property is damaged due to a homicide, a suicide, a search warrant issued where floorboards are pulled up and doors are kicked down, does insurance cover it? And who's responsible for cleaning up the damage to the property? Because law enforcement doesn't cover any of that. You are left to handle that damage. But I imagine most homeowners insurance also aren't covering if your, door gets battery rammed in by, like, I don't know, the FBI or whatever. So that's a question for another day. But the homeowner is generally the one responsible for all the damage. Well, the homeowner is renting the home out, and we know from trial that Diana Walshe is the one on the lease, and Brian Walshe and Ana Walshe were the ones living there. But it was rented and paid for. We learned in trial that Diana Walshe had paid 6 months of rent in advance at the time they rented the property for $5,000 a month, and it got reduced a little bit because she was paying 6 months up front. And this is for that property on 3A that we have seen pictures of in trial. This goes on to delineate who the parties are. I'm interested in the facts and the causes of action. Let's just go right there. Allegations applicable to all counts. On September 4th, 2019, plaintiff bought real estate located at 516 Chief Justice Cushing Highway in Cohasset, Norfolk County, Massachusetts. At the time of the purchase, and at all times relevant here too, the property was improved with a single-family home and in-ground swimming pool. The home, the pool, and surrounding landscape property are referred to as the property. On March 9th, 2022, defendant Walshe entered, and that is Diana. Remember, throughout all of this, we were talking about the mother. Defendant Walshe entered into a lease with the plaintiff for the property, which is attached, and the lease provided that defendant would occupy the property as a tenant from March 1st, 2022 through August 31st, 2022. And we heard at trial that this lease had been extended for an additional 6 months. At and before the time the lease was executed and delivered, defendant Walshe represented to plaintiff that she intended to occupy the property herself while recuperating from an illness and would be accompanied by her son and daughter-in-law and their 3 children who would act as caretakers. Plaintiff subsequently learned that defendant Walshe's son was named Brian Walshe and that his wife was named Ana Walshe. So they go through and list provisions of the agreement, and then they go through and list some of the lease that we have heard about at trial, about the rate of $5,000 per month. During the course of her and her family's occupancy to the property, defendant Walshe and her family damaged, defaced, misused, and abused the property in numerous ways and used the premises for improper and unlawful purposes, causing subsequent damage to the property, which will be very costly to repair. Those damages include, without limitation, the damages described in the following paragraphs. First, defendant Walshe and her family repeatedly placed their large German Shepherd dog in the rear fenced-in area of the property for unreasonably long periods of time and left the animal there unsupervised and uncontrolled. As a result, the dog incessantly scratched at the doors, the shingle siding, the window screens, and the fencing, causing substantial damage to the exterior of the house, the doors, and the fence. The dog was also permitted to dig up the landscaping in the backyard, leaving large areas bare of any grass. Okay. Second, defendant Walshe and her family punched numerous holes in the walls and ceilings of the home without repair. In one instance, defendant Walshe's son Brian entered the attic and punched his foot through the ceiling of his wife's bedroom, leaving a large hole of more than a foot in diameter. Also, challenge, I don't think a foot went through that ceiling based on what we've seen in the photos. That looked like a cut hole to me. Either way, the story from Brian Walshe is that he stepped through the ceiling. For this lawsuit, does it matter? No, but I still have questions about the hole in the ceiling. I have a lot of questions about the hole in the ceiling. They go on to say, third, defendant Walshe and her family abused and misused the in-ground swimming pool on the property. Among other things, defendant Walshe and her family members took rocks from the landscaping rock wall in the backyard and threw them in the pool, damaging both the surface of the pool and the rock wall. Because of this neglect and abuse, the in-ground pool has suffered substantial damage. The pool did not look good in the crime scene photos. Fourth, on or about January 1st, upon information and belief, defendant Walshe's son murdered and dismembered his wife, Ana, in the property. This caused blood and other human remains to contaminate the home, including the Walshes' bedroom, where the murder apparently took place, and the basement, where apparently the dismemberment and disposal took place. Now, we haven't gotten to the crime scene yet, but I imagine we're going to hear more about this at trial because we are just getting to the beginning of the crime scene individuals, and it took crime scene 2 days to process the house. I'm not surprised that this is alleged in this suit. It goes on to say that this contamination of the property required plaintiff to hire a company that specializes in decontamination of murder and other crime scenes at substantial cost. This decontamination process involved the full cleaning, treatment, and painting of the basement, the removal of the bedroom wood flooring, and the treatment of the underlying support structure. This is why I go through lawsuits with y'all. I was curious what this lawsuit was about. That's new information for me, that the subflooring apparently was also bloody enough that it needed to be removed. To me, that's not someone who died of natural causes in their bed, but we're still 2 weeks away from the end of this trial. They go on to say that the decontamination process also involved the thorough cleaning and decontamination of the bathrooms and other areas. Fifth, when the police learned of this murder, they conducted a full forensic examination and testing of the property, which caused substantial damage, including without limitation. The police took up part of the wood flooring in the Walshes' bedroom. We're going to hear about that. The police sprayed a purple blood-detecting liquid called luminol over numerous locations in the home, leaving stains on the walls, mattresses, furniture, and bathroom facilities like toilets, sinks, and showers. We saw this in the Murdaugh case too. Yeah, they're going to test the sinks and showers and everything that you could use to wash blood off. They're going to test all of that for blood. The police entered the attic and disturbed much of the insulation while looking for evidence, and the police dismantled, tested, and examined the filter for the in-ground pool, necessitating its replacement. Most of these damages were pointed out to defendant Walshe during her inspection of the property in January and February 2023. Nevertheless, defendant Walshe failed and refused to repair and remedy these items of substantial damage prior to surrendering possession of the property to plaintiff at the end of the lease term. I'm going to just put a reminder here again. Remember, up until late November 2025, it seems that Brian Walshe, presumably also his mother, were treating this as a, we don't even know anybody's been murdered. She might just be missing. It seems that that was the story then. It goes on to say that in addition to the tangible damages to the property because of the widely publicized murder committed in the property by Walshe's son, the property has now been psychologically impacted, which has substantially decreased its potential rental and sales value. I don't really know what psychologically impacted means, because that sentence seems to indicate that the home was psychologically impacted, but I think it's maybe individuals. But the home is tainted, for lack of a better word, by this crime. I would think that that's absolutely true. I've just not heard that phrase used in that way before. Maybe it's common in real estate. That's new to me. It goes on to talk about the insurance policy on the home, and they say that the damages to the home and injuries, it says, to the home are covered by insurance. They then say when plaintiff learned of the nature and extent of the physical damages caused to the property by the defendant and her family, plaintiff notified the MPIUA and made a claim for reimbursement. MPIUA hired an insurance adjuster, and then plaintiff was interviewed and the property was inspected. They go on to say that despite clear coverage, I mean, lawyers, am I right? Lawyers are like, this coverage is clear. Insurance companies are like, the fuck it is. So, despite the clear coverage provided by its insurance policy, on February 1st, 2023, the MPIUA agent wrote to plaintiff and denied coverage for any and all physical damages to the property. They're saying that that's in bad faith and on quote unquote spurious grounds. We're not going to get more into the fight with insurance. Oftentimes, insurance will not cover against things like negligence and willful actions. I don't know how that plays out when the homeowner didn't do anything wrong. The homeowner rented the property. They go on to say that during the period the plaintiff has been attempting to assess and repair the damages at the property caused by Walshe and her family and obtain recompense and reimbursement from defendants, plaintiff has been unable to rent the property to another tenant and therefore has lost the fair rental value of the property during this period. In addition, plaintiff anticipates that the repair and renovation required to remedy and correct the damages caused by defendant Walshe and her family will take a considerable amount of time, further extending the period which the property must sit idle and unoccupied. As a direct and proximate result of the wrongful and illegal acts and omissions of the defendants, plaintiff has suffered and continues to suffer substantial harm. I imagine also selling it wouldn't be easy at this point. So claim 1 is breach of contract against defendant Walshe for not paying for the damage caused to the property. Count 2 is breach of contract against the insurer, and those are the only counts in the lawsuit. And then there is a demand for jury trial here. So damage to the property seemingly can't be rented. It's going to have to be repaired and might not easily be able to be sold. The address is all over this trial. It is said so often. So it's not as if somebody would be unaware if this was on the market to rent or to sell. So I feel for the landlord in this, because what do? You rent a house and then all of this goes down, and depending on what happens at trial, he has still pled to the dismemberment and disposal of Ana Walshe, which seems to in no small way have damaged the home and is known and admitted to. So the nuances of can the prosecution prove that this is a first-degree premeditated murder aside, the house is still tainted by what people know happened. And what are you to do? But that's compounded by the fact that Brian Walshe's mom and attorney responded to this and denied claims, and then just noped out of engaging in discovery to the point that the landlord and his attorney filed numerous motions to compel discovery, which went ignored, and then started filing motions for default and sanctions. So we're going to look at those motions right now. All right, the docket that we are looking at is from September 4th, 2024, and you will see handwriting all over the side. The Massachusetts judges just write their orders right on in. And if you're like, girl, I can't even read that, don't worry. As we get to the end of this motion, I will read you what the judge ordered from the docket. We're going to go through the motion a little bit first. Motion to default defendant Ana Walshe and to sanction her counsel. Default means to rule against them. You lose. Different than what we've seen in like the TikTok psychic case where there was a motion for summary judgment, but this is a sanction against behavior. So it is a punishment, if you will, versus the summary judgment that is a finding of fact based on the motions. Part of why we're going through this is because this motion will lay out a timeline of what's been going on since this case was filed, and this will take us up to present. So we're going to get like a whole case in one episode, and I don't think that's ever happened. So landlord says that they are moving the court to enter a default against the defendant Ana Walshe for her blatant and unexcused violation of the court's orders entered July 3rd, 2024, copies which are attached, which we will see. And then they lay out the timeline of what's been going on. On December 26, 2023, plaintiff landlord served defendant Walshe, Brian Walshe's mother, both a Rule 34 request for documents and the first set of interrogatories. Interrogatories are the questions, like answer these questions and tell us things. And then requests for documents are give us this shit so we can look at it. They say Walshe ignored both discovery requests. On February 1st, 2024, plaintiff served Walshe with a motion to compel the production of documents. Walshe also ignored this motion, and on February 27th, 2024, plaintiff filed the unopposed motion with the court. On February 20th, 2024, plaintiff Landlord served Walshe a motion to compel to answer the interrogatories. Answer the question. Walshe also ignored this motion, and on March 20th, plaintiff filed this unopposed motion with the court. On July 1st, counsel spoke, the lawyers, and Walsh's counsel agreed to provide Walsh's responses to plaintiff's discovery by July 15th. On July 3rd, the court issued 2 orders attached, which were orders to compel. It was answer it. Now, one order allowed plaintiff's motion to compel the production of documents ordering that, quote, Walsh's objections are deemed waived. That's the find out. Like, you fucked around and now you find out. You didn't want to answer all the discovery and you didn't want to answer the interrogatories. So instead of having the opportunity to object to the questions, you just have to answer the question. Walsh's objections are deemed waived. Walshe shall provide answers to interrogatories by July 14th or risk default and or sanctions. Defendant Walshe finally responded to plaintiff's discovery request in mid-July. On July 16th, that wasn't the date. If they're telling you you're going to default, at least meet the deadline. On July 16th, Walsh's counsel served what purported to be Walsh's responses to interrogatories, a copy of which is attached. Some of those interrogatory questions are spicy. We're going to take a look at those too. On July 17th, 2024, Walsh's counsel served what purported to be Walsh's response to plaintiff's Rule 34 request for documents. It's their discovery section. You keep hearing about Rule 34. It's their discovery section in Massachusetts. As the court can see, Walsh's responses are littered with numerous objections in direct contempt of the court's orders, stating that all such objections are waived. For example, Walshe refused to answer interrogatories numbers 16 through 26 on the purported basis that the interrogatories exceeded the number of interrogatories permitted. These objections were endorsed in the defendant's answers by her counsel. Likewise, Walsh's response to plaintiff's Rule 34 request contains numerous objections, all of which the court ordered were waived. They go on to say the assertion of objections in response to plaintiff's discovery request were expressly forbidden by the court in its 2 July 3rd orders. Yeah, you waived your objections, and now they are verboten. The landlord's attorney is again asking the court to make them do what they were ordered to do. So let's go take a look at the attachments. Also, Emily, what judge? Judge Claudine Cloutier? Cloutier. Emily, when you just read that as clout, you've been on the internet too long. Yes, Cloutier. Like Cartier, but with clout. Emily, what's happening? I don't know. It's been a long week of trial. But it's not a judge that we've been talking about. So it's a different Judge C. It's all good. The orders are as they are represented. You must respond or risk default. Exhibit B are the interrogatories. And so some of these are the interrogatory questions we would expect. Identify who might know about this, anybody who might have documents about this, any documents that exist. But then we get to the later interrogatories. Interrogatory number 17. Did your son, Brian Walshe, murder his wife, Ana Walshe, in or upon the property? Response. This exceeds the number of interrogatories permitted. And that is the answer to all of these. This exceeds the number of interrogatories permitted. Remember, all of them are waived. Interrogatory number 18. Did you conspire with your son, Brian Walshe, to commit the murder of his wife, Ana Walshe? Interrogatory number 19. Did your son, Brian Walshe, dismember the dead body of his wife, Ana Walshe, in or upon the plaintiff's property? Interrogatory 20. Within the weeks or months prior to Ana Walshe's disappearance, did you hire a private investigator to investigate any matters relating to or concerning Ana Walshe? Unless your response to this interrogatory is an unqualified no, please identify the private investigator, state the reasons why you hired the private investigator, and identify each and every document that relates to your hiring of this private investigator and any communications you had with the private investigator. We've heard about the private investigator in trial, but we don't have more information yet. And in trial, I very much want to know, Brian Walshe knew about Ana Walshe's affair leading up to New Year's. And then they get back to talking about the lease. Also, as part of the responses here, we see Diana Walshe answering for herself, even though she is the one who leased the property, saying things like, quote, "I never left the dog in the backyard or anywhere else. I never punched any holes in the wall. I never abused the pool. I don't know of any murder being committed. The alleged damages listed were not pointed out to me. I don't know what psychologically impacted means, nor whether this is a real thing." I mean, on that we can agree. "I never occupied the premises as a tenant, nor did I damage the property. But you rented it under your name." But there we see the "I don't know of any murder being committed." Interesting. I know your question is now, well, Emily, what did the court do? I'll tell you. So all the writing that we saw, we are now looking at on the docket instead of trying to read it sideways. It says endorsement on motion to default defendant Diana Walshe and to sanction her counsel allowed in part. The arguments presented by Walshe are untimely. Walshe must provide full discovery responses without objections, as such has been waived. However, this is an interesting however. However, the court has not deemed any Fifth Amendment privilege to be waived. Should the defendant seek to assert such privilege in light of the assertions and objections without first moving the court for permission to assert them following the July 3rd order, the court will award sanctions in the form of legal fees incurred in connection with the preparation of this motion only. The court will not enter default in light of the discovery responses that were provided. Thus, within 14 days, the defendant is to provide complete discovery responses without objection to plaintiff's counsel. So the court is saying, look, I ordered without objection. And if you were going to object on Fifth Amendment grounds, you needed to run it by the court. Fifth Amendment grounds weren't yet asserted here, but they could be. On did you conspire with your son to murder his wife, you could assert a Fifth Amendment ground to that and not answer it. So what does Diana Walshe do next? Well, she files an emergency motion to stay the order compelling discovery, which is promptly denied. This court is so over it at this point, and you can see it in the next motion that we're going to look at. Emily, there's more? Yeah, there's more. Diana Walshe, through her attorney, filed to stay discovery, meaning they wanted to pause discovery, and they were going to file some additional motions. And the court went, no, you aren't. You're not pausing discovery. You need to answer this. So I ordered you to answer it in July. You didn't. I didn't grant a default, and I ordered you to answer it without objection, and you didn't. Then I ordered you again to answer it, and you filed a motion for a stay of discovery. No. So we are now at September 27th, 2024. Plaintiff's opposition to defendant Walshe's emergency motion to stay order compelling discovery and cross motion for default. They are asking again to default this case. They say plaintiff moves the court to default defendant Diana Walshe for her continued refusal to respond to discovery and her contempt of this court's clear order entered June 12th, 2024, requiring her and her counsel to respond to plaintiff's outstanding discovery request no later than 14 days after the entry of the order, which was September 26th, 2024. Those dates don't make a lot of sense to me because there was a July order in between there, but either way. Instead of complying with the court's order, defendant Walshe and her counsel waited until literally the last minute, then electronically filed this frivolous motion asking for more time. This new gambit should be denied and defendant Walshe should finally be defaulted. As further grounds for this opposition and cross motion, plaintiff states the following. And they go through the timeline that we just went through in the other motion and reminded the court of all the times the court ordered discovery. And then the fact that they were supposed to answer discovery without objections and objected anyway. They then say in direct contempt of the court's orders, Walshe asserts numerous objections which the court has already ruled were waived. Based on these objections, Walshe refused to produce most of the information sought by plaintiff. Immediately upon receipt of these discovery responses, plaintiff served his motion to default Diana Walshe and to sanction her counsel dated August 8th. The Rule 9A package on this motion, including the opposition from defendant Walshe, was filed with the court September 3rd, 2024. Upon review of that motion, the court ruled that a hearing is not necessary and ordered that within 14 days, defendant Walshe is to provide complete discovery responses without objections. Docket entry from September 12th, 2024. That's what we were just looking at. Since the order was docketed on June 12th and the 14-day period provided in the order expired September 26th, in contempt of this court's order, defendant Walshe did not provide any revised discovery responses during this 14-day period. Instead, defendant Walshe's counsel waited until the last minute to file this emergency motion. In the motion, he asked for a brief stay for the court to rule on 3 new motions that defendant Walshe now claims they will be filing. In the motion, Walshe says she is served contemporaneously with the motion at the same time. A motion for clarification, a motion for protective order, and a motion to transfer to the housing court. So no longer in Superior Court, move it to a different court. This lawsuit was filed in May of 2023. And in September of 2024, they're like, time out, we'd like to go to a different court. They go on to say that the third motion, the request to transfer to housing court, has already been filed by defendant Walshe twice and denied twice. Oh, so they didn't wait all that time. They keep trying it. Okay, fair. They go on to say it is clear from the past behavior that the present emergency motion is filed in bad faith and solely as a further stall tactic. It is time that defendant Walshe pay the price of her intransigent refusal to provide discovery in this action. It is time for the court to default Walshe. And what does the court rule? October 2nd, 2024, plaintiff's motion for default will be scheduled for hearing. So they scheduled the default for hearing. And then on October 3rd, 2024, the endorsement, which is the judge's writing on the motion that we just looked at, is docketed and a hearing is scheduled. The hearing is held on October 31st, 2024. And on November 1st, 2024, the court allows the cross motion and says, quote, the motion for default is allowed after hearing for defendant's repeated and willful disregard for this court's discovery orders. That means that the breach of contract is found. The defendant is liable for breach of contract, responsible for breach of contract. The factual part of the case is done, and this defendant has lost. So the court defaults Ana Walshe. So she is now responsible for the damages. Leaves one question. How much are you going to have to pay? So what does Ana Walshe do? Well, on November 6, 2024, they file an emergency motion to transfer to housing court. That's denied on the next day. The court endorsement says, well, no action taken because the default has already been entered. You can't get transferred. Then what does Ana Walshe and her attorney do? They appeal it, and they appeal the denial of moving it to housing court. And so the next docketed item is on January 2nd, 2025, because it was stayed pending appeal. Emily, what happened? The appeal was denied. So the petition is denied. And the judge then in March of 2025 asks for a status review. And a status review is updated with the court September 3rd, 2025. And on September 3rd, 2025, the plaintiff's attorney says, look, we have a default for Ana Walshe. We need to deal with how much damage and the amount that she is defaulted for. And we need to continue to move forward with the insurance companies. And the next date for that has been docketed in February 2026. But at the end of the day, Ana Walshe and her attorney fucked around and found out. They put off discovery and answering discovery to the point that she defaulted in this case. And at some point, a default judgment will attach to her with whatever the amount of damage to the property is. So we're going to have to wait and see. I'm very curious how much the monetary value of that is, but she has lost this case by not complying with discovery. Why is she fighting so hard to not comply with discovery? I can guess at what y'all are going to say in the comments. So I'm going to be keeping an eye on this docket. Let me know if you want me to keep an eye on this docket. I already told you I'm going to, but I want to know if you also are now curious. how much damage to the house? And will she have to pay it? It seems that she has some means to do so. She was paying 6 months of $5,000 a month rent in one go. Really, really interested to see what happens next in this case. Let me know if you are too. And speaking of a case we're very interested in, real quick, Emily, isn't Ron back in court? Yes. Real briefly. Well, Landlord, depending on where you live, it is definitely becoming sweater weather. And truly, we are just in full holiday season over here. So if you are ready for the season's festivities, but want to make sure you are feeling your best, our sponsor, Honeylove, has you covered. Honeylove is designed to work with your body, not against it. And isn't that what we need? No more digging in of straps or poking underwire and constantly adjusting. Just breathable support that feels like a second skin. So if you're ready to refresh your bra drawer, now is the time. Ditch the discomfort and step into confidence this season. And when you are ready to slip out of all those looks at the end of the day, do not sleep on the Honeylove sleepwear. It is my favorite sleepwear on the market, and it is actually cooling, which feels good all year round. So from bras and shapewear to sleepwear, make sure that you use our link to treat yourself to something special. And if you are looking for a recommendation, Honeylove recently launched their new Cloud Embrace bra, which sold out in days and is back in stock. So make sure to check it out for yourself. So if you're ready to save 20% site-wide at Honeylove, use our link at honeylove.com/Lawnerd. That's honeylove.com/Lawnerd for 20% off site-wide. And if they ask how you heard about them, let them know it was the Emily Show. So get ready to treat yourself or someone special to the most comfortable and innovative bras on earth this holiday season. Let's get back to today's episode. In the Cardi B case, the plaintiff's attorney is someone that we have been following a little bit, especially with regard to the sanction motion and sanction hearing. The court held the contempt hearing on December 5th, along with the motion for new trial. The motion for new trial was denied. We knew the motion for new trial was going to be denied. I'm more curious about what happened on the sanction hearing. Let's take a look at that real quick. The minute order from December 5th says that the court's tentative ruling as to the contempt hearing was presented to all parties in open court. I'm going to need to look at that tentative ruling. I'm very curious. When I have that tentative ruling, I will let you know. But based on the fact that the court said that they might sua sponte of their own motion, bring a contempt proceeding, I think that the court's ruling is like, you're going to be held in contempt. The question is how much. That's what I think is going to happen. But again, I would like to see. Counsel Peter Anderson is sworn to testify for the court on the sanctionable costs. If the court is not going to award sanctions for contempt, you don't swear in an attorney and put them on the stand and ask how much it cost. After reading and considering all moving papers, hearing arguments, and conferring with counsel for plaintiff and counsel for defendant, the court takes the matter under submission. So we don't have an answer yet because the court has taken it under submission. I hope what that means is that he is going to find attorney Ron in contempt, and he's just trying to figure out how much money it's for. I'm thinking that's probably what's going to happen. One other interesting thing to note, Ron did not appear in court. He appeared via LA Court Connect. He appeared in court for his own contempt hearing on Zoom. What in the world are you doing? The other side was all in court and had another attorney in court in case they needed an attorney that wasn't involved in this. You know who else didn't appear? Ron's supposed attorney. Ron in his motions where he was whining ad nauseum about, I can't fully defend myself now because I'm waiting for my attorney. No attorney appeared for him. I could only imagine how pissed the court must have been. He appeared via Court Connect for his contempt hearing. Wild. And you know what else? He didn't testify. He wasn't sworn in to testify in his own contempt proceedings. So that leads me to believe that the court's indicated ruling is that he was finding contempt based on the record because it's pretty fucking clear. And the only question is, how much? So it seems that both the cases we covered at the end of the show today, the only question remains, how much money are you going to have to pay? And I'm going to keep an eye on that. And when we know how much money, I'll let you know. I need my register sound. I need the cha-ching. Editors are going to be like, yep, I got you. Emily, you seem awfully joyful. Look, attorneys that fuck around in the way that we have watched in this case hurt the clients that hire them. They take up an inordinate amount of time in the court system, and they make the profession worse. So yeah, when they spend a lot of time in law school, and maybe they don't do this anymore, I'm old, but when they spend a lot of time in law school telling lawyers that they're going to be basically disbarred if their attorney trust account is off by 15 cents, and then you see the Girardi and the Murdaugh of it all, you start to wonder why there aren't any consequences. You opt into this profession. It's not like you just accidentally trip and become a lawyer. It is difficult. I mean, it's gotten easier, but Ron's been an attorney for over 20 years. It was still a 3-day bar exam back then. It's difficult to become a lawyer. Law school's expensive. You have to pay the state bar every year. You have things you have to do to maintain your license. There should be sanctions for things that go beyond mistake. Willful contempt is what we saw happen in the Cardi B trial from the plaintiff's attorney. And it still leads me to, I think the only reasonable conclusion is that he took that case because he figured that Cardi B would just write a check. And I'm glad she didn't. Good. It takes up court time and resources from cases that need the attention. And honestly, it's just fuckery. Emily, is there anything you're not mad about? I mean, we're entertained, but the fact that this attorney is still a menace in the hallways is a whole other thing. And law nerds, we still have more Ron motions to go through because A, we're waiting for the court's ruling on this, but we still have to go through all the motions about the fact that that office that he was talking about apparently is not his office. And there is a magician. I'm quoting from the process server. There is a magician who accepts Ron's mail at that office on Wilshire. I'm not joking. We need to go through all of those motions because Ron's office isn't even Ron's office because he got kicked out of that office 15 years ago after getting into a spat in the hallway. But that's for another day. Law Nerd, thank you for being here. Thank you for being a Law Nerd. We've got to get to court. I will see you in court for Massachusetts versus Brian Walshe. Make sure you have the Law Nerd app so you know when we are going live because it's a very busy time of year. So the schedule has been fluctuating day by day. And thank you again for making us the #1 place to watch trials anywhere. Truly, we have the highest viewership anywhere. Network, non-network. You guys have just absolutely made it a pleasure to be in the chat with y'all every day as we go through the difficult bits of trial, the horrific bits of trial, and sometimes the slow prodding through tech information and experts trying to explain the difference between an SMS text, an iMessage, and doing it badly. So thank you for being with me for every day of trial. Thank you for being here. Thank you for being a Law Nerd. Take care of yourselves. Take care of each other. And I will see you in the next one. Bye. Oh, that's not the gavel. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.